I request all to kindly maintain decorum and put your mobile on silent mode as we are live on YouTube. Now we are proceeding towards the second round of the technical session. Having the sub-theme Judicial Activism, this service Judicial Restraint, striking the right balance in ensuring judicial accountability. The session chair for this session will be Mrs. Hiranyamai Mishra. The session The session chair for this session will be Mrs. Hiranyamai Mishra. Mrs. Hiranyamai Mishra is the Head of Department LLB and LLM, Director CDC at Madhusudan Law University. Madam, am I audible to you? Thank you, ma'am. Thank you for confirming. She has been serving as an assistant professor in the same university since 2016. Prior to joining this institution, she worked as an assistant professor at National Law University, Odisha. She completed her LLM in corporate and commercial law in the year 2014 from National Law University, Odisha. After earning her BA LLB honors in constitutional law in 2013 from School of Law, KIT University, Bhubaneswar, and qualified UGC NEET in 2014. She is currently pursuing her PhD from National Law University. Her areas of interest includes constitutional law, jurisprudence, access to justice, and human rights. She has participated in various national and international conferences and seminars. She has several research publications published to her credit. The rapporteur for this session will be Dr. Monisha Bishwal. Over to you, ma'am.
Very good afternoon to each and everyone. Respected session chair, distinguished presenters and participants, I welcome you all to this technical session on the topic Judicial Activism, vis-a-vis Judicial Restraint, striking the right balance in ensuring judicial accountability. May I request all the presenters to kindly adhere strictly to the allotted 5 minutes time limit. To ensure smooth proceedings, please introduce first of all yourself, and with the permission of the session chair, we shall now begin the presentation. Ma'am, would you like to address the occasion, madam? Am I audible, madam? The first presenter for this technical session is Dr. Chunuram Soren. And the topic is Judicial Activism, vis-a-vis Judicial Restraint, striking the right balance in ensuring judicial accountability.
Respected all the dignitaries of the dais. Great thanks to all the faculties members and also organizing members of this dais and dearest my participants. Today's my discussion topic is judicial activism is judicial restraint, striking the right balance in ensuring judicial accountability. Everybody knows law is the active agent of social engineering for social profits. Judiciary is the pillar of democracy and law plays a very important role in the administration of justice. Law begins to society as soon as the society begins to grow. It is not invented up extra in a specific stage of development. India is a parliamentary form of government. There are three organs in our state governance. First one is the legislature, which is accountable for passing laws, schemes, policies for the state. Second one is the executive, which is responsible for execute the law, scheme, policies for the state. Third one is the judiciary system, which is the highest organ of the judiciary system for the state governance. Even there is a separations of activities of three organs. They should balance together to maintain the accountability of the state. Judicial activism is a one kind of power functions of the judges in the court. And in India, the Supreme Court and High Courts are vested the power to judicial activism, and they should apply their power in their judicial philosophy. That means they should control their power, do not overtake the Lakshmana Rekha. That means do not use the another power. That means the power of the politics or the power of the bureaucrats. So, example of this judicial activism, I want to expose here. The UGC regulation by Equity Regulation Act 2026, which was decided on 13th January 2026. In this case, when this act was passed by the Parliament of India, but this act was rejected by the Supreme Court of India. Why? Because it violated the Article 14 of the Indian Constitution. Equality in equality. Because number of allegations was filed by the different states in the Supreme Court. Second one is the judicial restraint. Judicial restraint is the opposite of the judicial activism. That means the judges should decide the case on the precedent, but not only the opinion of the politicians. In this case, I want to expose here the case. The CJI, means the Chief Justice of India, B.R. Gavai, on 16th November 2025, this case was heard on the matter of the demolition of the Vishnu Temple of Madhya Pradesh. And in this case, demolition case of the Vishnu Temple of Madhya Pradesh, this case was filed by the petitioner advocate, senior advocate, 71 years of senior advocate, Rakesh Kishan. But the CJI rejected his case, and this Vishnu temple will be demolished.
Sir, can you be little fast because we are running short of time.
So thanks. So I am not explaining briefly. So This case was very briefly I cannot say. The last one is the judicial restraint. Judicial restraint is the principles of the judges to responsible to decision, action, and conduct the behavior. And this case has been, what I am explaining, this case, recent case on February 2026 was decided. This case was Atharva Chaturvedi. This case is on the reservation of EBC. He has the Atharva Chaturvedi, a student of medical student, he has qualified 2 times medical case, but he would not admitted in the medical colleges, any medical colleges. So he filed a petition in the case, and this case was decided by the recent CGI of India, Suryakant, and this he allotted in the medical college. Lastly, I want to suggest in this judicial activity, judicial restraint and judicial responsibility, that establishing judicial committee for the examine of 3 benches, the 3 organs, and they should, the responsibility of the judges should be, must be needed, and they maintain the philosophy of the law, power, and action. Thanks you to all.
Our second participant is Shakti Ranjan Behra.
Respected dignitaries and esteemed member of this seminar, my name is Shakti Ranjan Behra from Others College of Law, Angul. Today my seminar topic is judicial activism, judicial restraint, and striking the right balance, ensuring judicial accountability or answerability. So let's proceed. Okay, we will discuss the details of the judicial activism and judicial restraint in the upcoming slide. Here is back, sir. Here it is written, it highlights their role in shaping legal precedents. So precedents means the previous judgment. According to the previous judgments, the judges take different legal procedures. Next slide. Okay. So, what is judicial activism? Judicial activism means court interprets the law beyond its restriction, and through judicial activism, our judiciary promotes social justice and welfare, and restrain other organ to involve in judiciary matter. So these are the 4 elements of judicial activism, or we can say these are the 4 applications. The first application is protection of fundamental rights. Through judicial activism, we protect our fundamental rights. For example, the PILs, public interest litigations. The judicial investigates different type of corruption matter, and protection of fundamental right. Another example is the expansion of Article 21, that is right to life, which also include right to education, right to health, and right to privacy. So it is due to judicial activism we achieve this. We achieve protection of fundamental right. Next, filling legislative gaps. Sometimes what the legislature makes ambiguous laws. So to tackle with this situation, review the other organ, that is legislature and executive, to perform within their limit. And the fourth element is the environmental protection. And the environmental protection is like we have a case MC Mehta versus Union of India, where our court issues various guidelines regarding the protection of industrial hazards. So here the court follows different principle like pollutant pay principle, sustainable development principle. Okay, next here the case study regarding to our judicial activism is Visakha versus State of Rajasthan and DK Vasu versus State of West Bengal. Next sir. Okay, judicial restraint is basically here the judicial says to other organ like executive and legislature, okay, you do your duty, I will not intervene into your matter. So these are the key features like promotion of judicial constraint, respect for precedents, and avoidance of activism. Next sir. Okay, one of the key element is the separation of power. Is the main features of main features of judicial restraints in our country. It is not only the separation of power; it is the functional separation of power. Functional separation of power, like our judges are appointed by the executive, and our judges are also impeached by the legislature. So this is the separation of powers. Next, sir. Here is a case studies regarding to judicial restraint. The 1994 SR Bomai versus Union of India Supreme Court, and next Supreme versus Union of India. I'm not going details to the case laws. Next, here's the differentiation what judges do and what judges should do in case of restraint, what judges should do in case of activism. Okay, sir. So, our main objective of judicial activism and judicial restraint is to achieve what constitutional interpretation. The judicial in judicial activism protects our fundamental rights. It governs social justice. On the other hand, its drawback excess judicial activism will result in judicial overreach. In case of judicial restraint, play a vital role in the separation of power. But excess judicial restraints will result in injustice in the society. So we have to balance the both. A pragmatic approach is needed to maintain the balance of both. So this is all about. Thank you, sir.
Madam, any
Yes, madam, you are audible.
So I can't say right now, sir. We should maintain vision because the judges are not the people's representative. They will do monopolistic work if we allow them to do for our society. So, thank you, ma'am.
shall I proceed to the next presenter, madam? Subhasis Das.
Good afternoon, everyone. I am Subhashis Das, second year law, Lingaraj Law College, Baramur. Today, we are diving into the heart of our democracy, the judiciary. Alexander Hamilton once said, the judiciary is the least dangerous branch because it has neither the sword of the executive or nor the purse of the legislature. It has only its judgment. But in 21st century in India, the least dangerous branch has become a most powerful institution in the world. Why? Because of public trust. When citizen approaches the court, they are not just looking for the law, they are looking for a sanctuary. However, with 15 million cases, the trust is under pressure. Today we explore how accountability and independence are not rivals, they are the partners. Next slide, please. To understand the judicial power, we must look at the two opposing philosophies, activism, judicial activism and judicial restraint. Think of judicial activism as the sword of the justice. It's the proactive role the court plays to fill gaps where the law is silent. On the flip side, judicial restraint is the shield of democracy. It's the self-discipline a judge exercises to stay out of politics and respect the people's elected representatives. The challenge for any modern judge is finding the golden mean, being activist enough to protect the weak, but restrained enough to respect the separation of powers. When the system fails, the public looks at the court as a last resort. We saw this in 1979 with the Hussain Nara Khatun case, which has given the PIL. The court realized that if it waited for the formal paperwork from illiterate under trials, they would die in jail only. Second slide. In more recent times, cases like Nirbhaya case, Unnao and Katwa case showed us accountable activism. In the Nirbhaya case, the court did not just pass a judgment, it forced the legislature to overhaul or change the criminal laws. When the court acts as the sentinel on the kiwi, the watchful guardian, it restores the public's belief that no one, not even the politically powerful, is above the law. Whereas the greatest act of activism in global history happened right here in India, the basic structure doctrine from Kesavananda Bharati case. By saying Parliament cannot touch the soul of the Constitution, the court cemented itself as the final guardian. However, power brings scrutiny. The NJAC case of 2015 is a perfect example of accountability paradox. The court struck down the commission to protect its independence, but in doing so, it faced criticism for being a self-appointing body. This tells us one thing: to maintain the trust, the judiciary must be transparent in the internal appointments as it is in the public judgment. Next slide. Former CTI D.Y. Chandrachud often spoke of the law as a living organism. His philosophy was one of the principled activism. He believed the court should fiercely activist in matters of personal liberty, like decriminalizing Section 377, but should exercise deep restraint in the policy matters of the legislature. He famously said, the court's role is to ensure the music of the Constitution plays on, and not to write the lyrics of the governance. By acknowledging the judges are not experts in the economics or engineering, the court actually gains more respect. Restraint is not a sign of weakness, it's a recognition of institutional limitations. Next slide.
Could you please conclude first?
To conclude, how do we strengthen the public trust? I propose a 4-pillar strategy. The functional accountability. We need to end the tariq pe tariq culture with the scientific case management. With the institutional transparency, The secrecy of the robe must give way to clear criteria for judicial appointments. Intellectual restraint. Judges must avoid the political thicket to keep their neutrality intact, and the corrective activism, using the sword only as an emergency break when the state fails. In conclusion, I just like to say public trust is like a fragile glass. Once broken, it is nearly impossible to repair. By embracing accountability, the Indian judiciary ensures that the temple of justice remains a sanctuary for every citizen. Thank you.
Any question, madam? Okay, madam. Sunita Katra.
Esteemed Session Chair, Mrs. Hiranmai Mishra Ma'am, most respected rapporteur of the session, Dr. Manisha Vishwa, respected faculty members, and my dear participants. I'm delighted to have such an opportunity to take part in this 2 days national seminar on the topic Judicial Accountability. And my core topic for this session is Judicial Activism versus Judicial Restraint. Another way we can say it as guardianship versus self-restraint of judiciary. So salute to our constitution framers for gifting such a magnificent, comprehensive, adaptable and a foundational document that has guided their nation for decades. The constitution is not merely a document, a legal document, it is the soul of our democracy because it transforms the individuals into a responsible citizen. Coming to the seminar topic, judicial accountability, strengthening public trust in the judicial system, the two emphatic words, judicial and the public. Both of them, the constitution is the supreme power or supreme source of power. Henceforth, it is rightly said that हमारा हर तकलीफों का मैं एक मुकम्मल जवाब हो, कभी वक्त मिले तो मुझे पढ़ना मैं भारत का संविधान हो. It is well known that the independence of the judiciary is the cornerstone for our democracy, ensuring courts to make impartial judgments or decisions based on law, free from executive, legislative, or external pressure. So also it ensures the fair trial by separating the judicial functions from the political influence. At the same instance, we know very well that power without accountability risks arbitrariness. In a democracy governed by the rule of law, even the judiciary is the final interpreter of the constitution and also the guardian of our constitution cannot be above the scrutiny. As observed by the Supreme Court of India, the judicial independence is not the privilege of the judges, rather it is a responsibility owed to the people. The Union government's impeachment motion against the Allahabad High Court judge following the allegation of financial misconduct brings the judicial accountability into sharp focus. In simpler form, judicial accountability is the mechanism that balances the independence given to the judiciary with its responsibility. The current judicial accountability mechanism, such as the Judges Enquiry Act, are often insufficient and politically influenced. To strengthen the accountability, the establishment of an independent judicial oversight body, the revamping of the impeachment process, the public disclosure of judicial assets and liabilities, strengthening the in-house mechanism with transparency, and the judicial performance review and reporting, and the whistleblower protection for the judicial misconduct, the institutionalization of the ethical standards are needed. Coming to the topic judicial activism versus restraint. What exactly these two? These two judicial philosophies are shaping the modern constitutional governance, are the binary philosophies in which the judicial activism and restraint they form a spectrum of the judicial behavior influenced by our constitutional needs, socio-political context, and the institutional legitimacy. Judicial activism, where the courts play a very active role in addressing the societal issues, interpreting the constitutional issue broadly, and correcting the injustices when other branches fail to act. That is, courts go beyond the strict application of law, sometimes seen as legislating from the bench, primarily which focus on the public interest litigations and protection of fundamental rights. The Supreme Court of India has firmly asserted that the judiciary cannot remain a silent spectator when the constitutional values are at stake. The judiciary has historically used the judicial activism. Yes, ma'am. Coming to the conclusion part of this topic, judicial activism and restraint are not opposites, but they are the complementary doctrines. Excess of activism leads to overreach, and excess of the restraint leads to injustice. It is very well known to each one. The ideal approach is to make a judicial balance that is guided by the constitutional morality and the democratic principles. The Indian judiciary journey reflects a dynamic equilibrium between the protecting rights and respecting the institutional boundaries. Yet, some steps to be taken for the improvement, and the judicial activism is necessary when the constitutional values are threatened, but judicial restraint is essential to preserve the democratic legitimacy. Thanking you all. Yes, ma'am. Ma'am, it is the basic structure doctrine that has asserted from the S1 and Bharati case, the independent judiciary. It has enshrined in that doctrine clearly. So I think the restraint is needed from the judiciary, but the other organs should not given that. Yes, yes, ma'am. Thank you very much.
Next presenter is Tanya Misra. Tanya Misra. Nine offline. Tanya Misra. Okay, next Dharanidhar Rana.
Respected degrees and all the intellectual audience,
sitting before this. My name is Dharinder Rana. I am from Balesur Law College. Being a first year student, my topic is reducing pendency of backlog cases, its challenges and its solutions. My topic presentation will be very crisp, divided into 4 subheadings. That is, what is the statistics of pendency of case logs in India according to National Judiciary Data Grid, and what are the causative factors, contributing factors for judicial pendency and case log, backlog of cases. Then what are the effect and impact on society and economy. Finally, what are the challenges we are facing and how the upcoming and suggestible solutions will be. Coming to the data grid, to the National Judicial Data Grid, the number of cases before various courts in our Indian context is roughly around 5.5 crores something, wherein there is a maximum load upon the subordinate courts in the Indian context. The Indian context of case load in subordinate courts contributes around 88%, something like that. So, when we focus upon the subordinate courts, we can find the maximum contribution of case loads in subordinate courts are there. Coming to the next slide, please. The average pendency in various courts is increasing year per year. When we research, when we do a study regarding the pendency of cases in subordinate courts, a case remains average 6 years to get disposal. Whether in upper cases like high courts, it lasts for 3 years. This, next slide please, this data shows where we are lagging and where we are lagging behind for easy disposal and smooth disposal of the cases, which increases the stacking of cases in different courts. This slide shows at the current rate, if whatever case loads we are having in different courts, it will go up to 10 more years to dispose of all the cases. Remaining the influx of the cases freeze. It will take 10 years to dismiss all the cases. So we have to address at this point. Next slide please. Many root causes of judicial pendency here in our context is various points like judge shortage and low ratio of judge and population, procedure complexities, government as a major litigant of various cases, almost maximum number of cases, infrastructure deficits, and limited area resolution systems. Next slide, please. These are the causes of judicial pendency in our Indian context. Next slide, please. So, profound repercussions on the society and economy is the underlying crisis, economic stagnation, social restraint, and eroding public trust upon our judicial system. So, what is the impact? Impact is a very crucial point here. This is a very vicious cycle. When it repeats, the case loads increase and go on further. So, technical reforms and digital transformation, what we are in practice nowadays, that is e-courts project, data-driven insights, hybrid proceedings since the pandemic, and the future imperatives. Next slide, please. Strengthening institution capacity is also important and factor which should be looked into, that is addressing the judicial vacancies, modernizing infrastructure and funding, enhancing judicial training also. Procedural and structural reforms will need the streamlined procedure. So smooth procedures could be suggested for our Indian cases, specialized judicial structures, proactive case management ideology which to be implemented in our different courts, and consistent implementation of the cases. So expanding alternate dispute resolution system is the need of in our case. As per the mandate of Honorable Supreme Court of India, the National Legal Services Authority is a very beautiful gift for the Indian societies, which establishes the grassroots justice at the level in the society, when the last person in the society may he or she be the underprivileged or any literate person or an influencing person. Justice should be there to the last citizen who is sitting in the remote areas. That should be addressed so far as our thoughts are concerned. And when we come to the path to expeditious justice, we should practice integrated reform strategies, preventive justice, and upholding constitutional vision. So when we come to the back of the basics, we should create a path where crimeless society is envisioned by our legendary predecessors. The main address should be to create a crimeless society and to increase the socio-economic status of the privileged, underprivileged, and influential people, and strengthening the community policing, where we can address the root cause of crime, where crime is being originated, why this such case high case influx is happening. We should set such precedents and a benchmark so that people will live in harmony. Coming to the conclusion, I must reiterate a remarkable judgment just in this month, February 13th, 2026, in the Honorable Court, SCST and First Track Court of Justice Ismail Akhtar Shamim. I hope almost have read this judgment. That is, an acid attack victim. Acid attack victim has been given justice, although the victim has succumbed to death on after 4 to 6 days in treatment. The main accused was sentenced to death by hanging with a fine of 50,000 rupees. This is the landmark judgment of Fast Track SST Court in Baleshwar. So unless and until we understand and feel the empathy of the aggrieved, the proactiveness cannot come into our mind. As a law fraternity, I must urge and I must expect all of us to go to that deeper so that we can give grassroots justice, like grassroots democracy in our Indian constitution. Grassroots justice, a term should be looked into. This is my deliberation. Thank you for your patience.
Yes, madam. Anjali Sasikant Sinde via online mode.
Okay, madam, no problem. Could you complete, could you conclude? Madam, could you please conclude? Okay, madam. Thank you so much. Thank you so much, madam.
Okay, madam. Benny Aurora and Ransom Stephen Coutinho via online mode.
थोड़ा पड़ला है देखो
Yes, madam. Sultana and Meghna Gunguskar.
I think Shireen is not available. So we can go for the next.
Ramati Kumari Panigrahi. Ramati Kumari Panigrahi. Absent.
Absent. Madam, all the paper presenters are over. Now you can conclude, madam. Thank you very much, madam, for being with us. Thank you, sir.
Hello everyone. Now, I would like to request Pramod Kumar Panda sir, Advocate, Barampur Bar. Sir, please, I would like to invite you to say a few words on this occasion.
Thank you. A warm afternoon to all of you. The dignitaries, not on the dais, but on the dais. I feel you all are the dignitaries who are present here on this August auspicious occasion of a seminar, which is a critical one to understand the legal fraternity and its impact on the society. Basically, my topic is on the basic point that the role of media in judicial accountability. So, being a social engineer, being a lawyer, and being a judiciary, part of the judiciary, being the PO, advocate, parties, all consist. The judiciary system thinks whether what type of act we have done, whether it can be accountable or not. This emphasizes on today's era by media. Media plays a pivotal role to influencing the judiciary not as well as to the society. Judiciary is influenced, society is influenced, we are also influenced by the media. So it impacts a high emphasis, it mobilizes the minds of the judges, advocates, parties, victims, accused, plaintiffs, defendants, complainants. So it impacts. So on this topic, what is today, that whether people have the trust on media, justice system, whether their accountability is going in a right way or it is moving in wrong direction, it is emphasized by the media today. So there is a high critic in the society that we are not getting justice. We are getting justice, somebody says. How? Because the judiciary runs with its own process and procedures. But when a order comes, people says that judiciary is not doing its work, judiciary is doing its work. So two conflicts are always there. So to put the exact trust in the minds of the public, the role of media is highly pivotal, no one can deny it. But though media plays a crucial role as a watchdog to the basic judicial actions and decisions, it ensures the public to fostering the environment of transparency and comprehensive coverage of legal proceedings and judicial conduct. So the media enables the citizens to be always stay informed about the basic functioning of the courts, the basic functioning of the judicial system in a proper direction to emphasize the democratic ethical values. It creates, encourages reforms when it wants to strengthen the public trust in judiciary. It promotes the legal system. So today you see in number of cases in every day we see in TV
in social media, everywhere, the media trial. The media trial directly emphasizes and impacts on the decision of the judiciary, which is highly accessible and accountable. Because if a judges see in the television in the night that something is done somewhere, we can take the great example of our own town, recent two highlighted cases. We will not go to the cases in Union versus of India, etc., etc. Lot of highlighted cases, media trials are there. But I want to say you, being you are all legal fraternity, have to understand the practical evidence of media role in two cases recently happened in Barampur. What is that? Can you say anyone? Yes. One case, another case is accident happened in Overbridge, Haldia. Now the Supreme Court has taken its own cognizance into the case and questioned the Chief Secretary of Odisha and appear before the Honorable Court by taking so much cognizance. So this is the effect and role of the media in judicial accountability. The judiciary is taking cognizance. It shows that we are accountable to the society. As last in this session we have discussed the Swadharma, the accountability, judicial activism, judicial restraint. Lot of things are there. My point is not to go down that way. Whole day you know what is judicial accountability, what is judicial accountability, everyone understand about the word, their responsibility. Okay. So first point, we should ensure why and how the media emphasizes the judicial process of accountability. See, in number of cases you see recent in IT Act 2000, it is a highly not acceptable act because nothing is clear in the act. You can't do anything to a cyber criminal. Can you do anything? So, section 65B previously, when media trials, media Facebook cases, you see recent blue cases also, specifically recent trade cases moving in social media, we are not being able to file cases against them. Judicial accountability is not there at the time. In Evidence Act 1850, section 65B has to face a lot of problems. You have to confirm that. But in IT Act recently 65, 63, subsection 4, 65, these sections clearly authentifies the recent media chatting, Facebook chatting, messaging, these are coming under Bharatiya Sakya Adhiniyam amended. You can take it as evidence. Though media what collected CCTV footage, etc., can be used as a evidence and it impacts on the judicial accountability. But also there is a pivotal role of the media that it should. Before concluding, I have got just 5 to 10 minutes time. So lot of things to discuss, but limited. I am a practical lawyer. I want to submit some practical facts before you. No doubt, academicians are given lot of academic aspects to you. My point, 2 to 3 points should be emphasized. Though I got this opportunity, that in recent case, as we have already discussed, being a investigating agency, media directly emphasize. You see, in the recent case of Vidhavas Ponda, what media trial makes, it affects victims as well as witnesses. So when a trial goes on, somebody feels it will affect victim and witnesses. So before concluding my point, my conclusion is that media directly affects, but the facts should be presented and the judiciary has utmost accountability and its effects on the judiciary is pivotal. So the conclusion, the dispensable role between the freedom of speech of the media with certain limitations and the judicial accountability is essential to uphold the values of the judicial system. Thank you for giving this opportunity. Before you all, I will feel blessed after 10 years I put my foot in this college. Though it is my favorite college, Lingaraj Law College, this college, being a lawyer, I always love you all and it is my privilege to be here with you all. And once again, I give my heartful thanks to my teacher, Vinay Pandey sir, and all the esteemed peoples who have given their heart and soul to make this organizing such a nice, beautiful seminar, and to all my student colleagues who are here and make it successful. Thank you once again. Thank you all.
Thank you very much, sir, for your energetic speech. Now, it is time to proceed with our third session. And let me introduce you all with the session chair, Professor Dr. N.C. Patnaik, Principal, Lingaraj Law College. Sir serves as the principal and also he is the reader in a subject, and Sir academic and administrative functions of the college, including the management of curriculum, faculty, and students' activities. He participates in many academic events and trains many students, research scholars, and guests representing the college in broader educational contexts. And he is also contributor to legal academic publications that includes his work in lectures on alternative dispute resolution in India. Though he is not there, but I introduced him with you all. And now, please welcome our rapporteur, faculty member, Mrs. Sudha Tarag, Assistant Professor, Ganjam Law College. Ma'am will take forward this session. Over to you, ma'am.
Thank you, Tarapriya. Good afternoon, everyone. As we are in the end, that is the third technical session. So, and we are also running short of time. So, I welcome you all to this third technical session on the role of media in the in promoting social and judicial accountability. Once again, I request all the presenters to kindly present here and adhere to their presence. About the session chair, who had to leave for some urgent work, and I sincerely regret his absence, but the session must go on. That's why we are quickly starting our third and final technical session with our most respected sir, that is Dr. Gopinath Das.
Good afternoon to all of you. There is a saying, where angels fear to tread, fools rush in. I do not have the technical competence or academic competence to deliver on the topic which has been assigned to me. I just try to limit myself with some stray thoughts that I feel I should share with you all. Dr. Rajendra Prasad was the first president of India. Before becoming the president, he was a practicing lawyer in the Patna High Court. He once argued in the court that, my lord, the justice in this case requires to this the Honorable Judge said, we are here not to give justice, but to give judgments. So when you talk about justice and judgment, there are different arenas, even though both of them are taken as one and the same. And Dr. Amartya Sen has defined in his book called The Idea of Justice in such a broad way that when we talk about justice, we normally do not speak only judgments that are given to us in a case, but justice has a broader term. That's why in the Constitution of India, in the preamble itself, the term justice means justice socio-economic and political. And media always catches the judiciary in not criticizing the judgment but giving the justice. And I would like to remind you that the first president of India, the previous president, Dr. K. R. Narayana, once cited one evidence which I am reading now. He says that even recently in one of the judges in India let a person accused of murder go free on the ground that clinching evidence was lacking, though the judge himself was convinced that the person didn't commit the deed he was charged with. So he says, mysterious are the ways of justice. That is why it has been said that the law court is not a cathedral, but a casino where so much depends on the throw of dice. This is the quote which was used by the then President of India, while inaugurating the Golden Jubilee celebration of the Supreme Court of India. And on the same breath, he also quoted our Chief Justice Dr. A.S. Anand, who said that access to unpolluted, inexpeditious, inexpensive justice, the people, instead of taking recourse to law, may be tempted to take the law into their own hands. So this is the caution Dr. A.S. Anand had given to the judiciary. If we do not give justice to the people, then people, instead of following the law, they will take law into their own hands. And in the last session and this session also, people have defined what judicial accountability is. I'll just throw upon 3 points. One is, as far as the judicial accountability is concerned, bridging the justice gap is one of the important components of judicial accountability. Bridging the justice gap. That is the chasm between those who need the protection of law and those who actually have access to it. The World Justice Report says that only 10% of the people reach a lawyer when they need one. This is an important point. So, this bridging the justice gap is not only the duty of the judiciary, but the society as a whole. Then my second point is that functioning justice system, which is the bedrock of our basic freedom, has to be ensured by the judiciary. So this is one of the aspects of judicial accountability. And one of the most important judicial accountability is self-reform of judiciary. Judiciary is not only accountable to the Constitution, to the people at large. Why I say they are accountable to the people? Because democracy is of the people, by the people, and for the people. What is the meaning of for the people? For the people means the people are the co-sharers of sovereignty, co-sharers of the power. That's why in the preamble it is said that we, the people of India, having solemnly resolved to constitute India into a democratic this. So the origin of the constitution is the people. So the sovereignty lies with the people at large. So the judiciary is also responsible to the people as a whole. And self-reform of the judiciary. I will give you one example in my presentation where the present Chief Justice has criticized the handbook prepared by the Supreme Court by the then Chief Justice Chandrachud and said that it is a Harvard-oriented handbook, which actually was misinterpreted by the Allahabad High Court in a rape case. In that handbook, it is said that preparation for rape and commission of rape are two things. Whereas, and in that case, the Allahabad High Court had set aside a case pertaining to rape, saying that uh, catching the breast of a minor girl and loosening the undergarment is not taken as a rape. So they say that it is not rape, but it is a preparation for rape. It is not a commission of rape. So to this, the Supreme Court took the so much cognizance and said and set aside that judgment of the High Court and ordered the trial court to go on with the trial. And so this shows that self-reform of the judiciary is one of the judicial responsibility, which is to be brought out by the media as a whole. And the other case studies I have given, which is there in the presentation, I did not go them into detail. But the point that we are on the cusp of change, both judiciary as well as the media. The media, I have given that there is an intersection where now the AI, uh, AI motivates now the contents of the media, the contents of the news is being monitored by the techno capitalists who actually play on with us. They are engaging with us. They are not finding the truth, but they engage with us. And as you know, our people have three basic ingredients to get from the news. One is hatred, number one is fear, third one is anger. So, in order to cater to those basic needs, which have been corrected, now the media parents ask the social media generators as well as the media from the press media to cater to these needs. So there is a danger of actually rail guard to those kinds of intervention, and I have given the media trial and black box problem because the algorithms now set the tone of the media contents. So this is a very dangerous thing. Yes, and I think with these words, I would conclude that nothing is perfect. So I end with an anecdote that first came Moses. He looked up at the sky and said, everything comes from heaven. Then comes Solomon. He looks little bit down and said, everything comes out of head. Then came Jesus Christ, who said, everything comes out of heart. Then came Karl Marx, who said, everything comes out of belly. Then came Sigmund Freud, who said, everything comes out of sex. Then came Einstein, who said, everything is a relative. So the relativity of the media and the relativity of the responsibility and accountability of the judiciary are to be understood in that light. Thank you.
Our next participant is Mr. Alok Kumar Kaur.
Good evening to one and all present over here, respected dignitaries on the dais. Myself, Alok Kumar Kaur, of Others College of Law, first year. I'm going to present the topic. That is media, that is the role of fourth estate and judicial accountability. Media is known as the fourth estate because it acts on as a crucial overseer on the three formal bodies of government, that is legislative, executive, and judicial. It focuses on the press power to save public opinion, to ensure transparency and safeguard democratic health. Now we are going to know about the media's role in judicial accountability. Media acts as a link between judicial accountability and public. It acts as a judicial bridge connecting the shield corridors of judiciary with the public. The Indian judiciary is independent, but the media coverage ensures transparency and informed citizen engagement. Investigative journalism and open justice. Our significant progress includes the Supreme Court judgment of 2018 ruling on live broadcasts making constitutional bench hearings accessible. In 2018, Supreme Court ruled in Swapnil Tiwari versus Supreme Court to allow live coverage of constitutional bench hearings. This landmark decision judicial transparency by making court proceedings accessible to the public in real time. Next, we move on to the other part of the presentation, that is the challenges and regulations of media trial. Media trial is often known as a threat to judiciary because the trial by media possesses significant risks to judicial fairness by shaping public opinion before formal judgments. High-profile cases like high-profile cases like Jessica Lal and Riya Chakraborty case demonstrate how sensationalist opinions of the people and presumption of innocence and undue populist pressure on judgments potentially compromising the integrity of judicial outcomes. Our article number 19, subsection 2 to 6 provides reasonable restrictions on media rights for reasons including defamation, contempt of court, and national security. These legal safeguards are essential to prevent media interference with ongoing trials and balancing public right to information and accused rights for fair trial. Hence, at last, I would like to conclude by saying that we need a balanced regulatory framework and a robust regulatory framework for integrating both media and judiciary hand by hand and bring the best outcome. Thank you all. Jai Hind, Jai Bharat.
The next participant is Tejaswini Paikrai.
Good afternoon, everyone. I am Tejaswini Paikare. I am a student of Kotala College, 5-year PLLB honors. And today I will explain discuss the role in media in promoting judicial accountability. Starting with introduction of my paper. The judiciary role, the ultimate guardian of the constitution and the rule of law. The power gap. Unlike the executive or legislative branches, the judiciary is not directly elected, making the alternative accountability machinery better. Media as the fourth estate acts as a bridge between the courtroom and the citizen. Then next, Defining judicial accountability. Accountability versus independency. Accountability does not mean political influence. It means being answerable for conduct and efficiency. Key facts. Legal accountability, institutional accountability, public accountability, keeping the judiciary aligned with the societal standards of justice. Then next, how media pursue accountability, reporting on judgments, scrutinizing judicial conduct, monitoring pendency, live streaming and digital access. The impact of trial by media. Warning. While scrutinizing is good, excessive influence can be harmful. The risks. Media houses sometimes declare a verdict before the judge does. Consequences. Criticism of public pursued against the accused. Reference on judgments to conform to popular opinion rather than the law. Potential violation of the presumption of innocence. Then next. The landmark cases and media intervention. Outcome. How media procedure focused a reopening of cases or led to systematic reforms in judicial amendments. Landmark case. Like the Jessica Lal case in India or the OJ simplification trial in the USA. Then next, challenges ethical boundaries, positive rule and negative risks. Positive rule, excessive corruption, concept systematic frauds, educates the masses. Then negative risks, sensationalism, concept of court, privacy violation. Then next, recommendation for a healthy relationship. Specialized legal reporting. Media houses should employ reports with legal reporting to avoid misreporting judgments. Responsible criticism. Difference between criticism a judgment and attacking a judge personally. Strengthening concept laws. Ensuring laws are used to protect the administration of justice, not to stimulate legislative, investigative journalism. Then next, to summarizing my main points. The media is a watchdog, not a bloodhound. Judicial accountability is strengthened when the media pursued objective facts-based criticizes. A transparent judiciary is a trusted. Thank you for your attention. Thank you so much.
Next, next presenter is Ashish Kumar Pradhan.
As timing is running short, so we would like to request everyone to conclude within 4 minutes.
Good afternoon, esteemed panels and of the dice. My name is Ashish Kumar Pradhan. I am from Lingaraj College, LLB first year. So, my topic is media trial and judicial accountability in India. So, I have chosen a case study. A film, No One Killed Jessica, directed by Raj, Rajkumar Gupta. So, here is the introduction. Growth of media influence in criminal justice. How the media influence to the accountability of the judicial and concept of media trial, where the media trials begins and examines how media scrutiny, public mobilization, and journalism influence appellate review and judicial accountability within constitutional constraints. So, I have chosen three objectives. Analyze legal dimensions, judicial accountability as reflected in the Jessica Lal case. So, I choose a film study perspective. So, how No One Killed Jessica portrays media activism affecting appellate review through content analysis, evaluate balance, weigh media intervention against judicial independence and fair trial rights. Next. So in the context, how high-profile murder cases where initial acquittal raised public outcry, sustained media coverage, exposed evidence lapses, witness intimidation, and investigating shortcomings, promoting unified scrutiny and appellate intervention. So in the film No One Killed Jessica, a journalist, Mira, she has overcome and come to the forward to give Jessica justice. So, as a film study narrative, one can Jessica dramatize investigative journalism and public mobilization. The film highlights media's role in spotlighting procedural failures and catalyzing institutional response, serving as a cultural accountant and external accountability mechanism. So, I chose thematic analysis as a methodology, doctrine analysis, and also secondary sources like magazine, journal, also the Times of India's front news. So it's the three key legal things: right for fair trial, protecting impartial adjudication, transparency and accountability, and public interest doctrine. So what is the roles of media? So media influence as a watchdog, like investigative reporting can reveal errors and mobilize remedial action. That happened in No One Killed Jessica film, also in the real life stories. So risk trial by media, excessive coverage may prejudice proceedings or undermine judicial independence. So with the constitutional framework, Article 19(1)(a), freedom of speech and expression. Then Article 21, right for life and fair trial. Open court principle, free face versus fair trial. So I have findings, public mobilization, sustained attention translate into institutional pressure for appellate review, investigative journalism. So as that for film, Radhika Mira, as a investigative reporter, she has overcome and unbiased media as a independent journalism. Media uncover inconsistency and witness issues to reopening the case. Appellate correlation. Appellate process correlate initial errors leading to conviction on review. So legal implication and tension. This study argues that responsible media scrutiny can reinforce constitutional accountability by exposing judicial and investigative errors. However, court must guard against prejudicial publicity to preserve fair trial, guarantee and judicial independence. So here is the conclusion part. Media can be corrective instrument when exercise responsibility. Safeguard needed, legal safeguard must prevent trial prejudice while allowing transparency. The Jessica Law's case exemplifies how media public pressure can prompt affiliate accountability. Thank you.
Next, we have Radharani Palam.
Respected sir and ma'am and my dear friends, today I present media trial and impact on fair trial and judicial independence. So we have we have already know many my before I started that I can say you we have to know in democracy democratic society media is the fourth pillar of democracy and in when fourth pillar of democracy. So, media is essential role in our society. It represent and it shows also a mirror of the society. So, when media is ruling, their role is when media is doing their role exactly what they have to do, then problem is arising that part. And nowadays we have to see many news channels is when any cases is arrive, news channels are showing media trials. In recently it was you have to see this case. You have to see media is informing many much. In accused person, you have to know in evidence. You have to know anything else, but in media, as decided accused. When court is not decided this accused, or it will be happen very much difficult to. We have trust to media, and the media is the exactly in article. Media is exactly is a conflict of between Article 19(1)(a) and which is decided to freedom of speech and expression, and Article 21, which includes the right to the fair and impartial trial. It will be conflicted situation right now in media. When media covers becomes sustain uh, became the role of judges, then why judges is in courtroom? So media is, I feel like media is controlling their line, and court is court is it's, also court have also their line. So media is not decided, and it will be impact in society, and people are influenced and biased, and they will say sport is doing wrong decisions and media is doing the right decisions. In this way, you have to see how people are truly believe in media, not in courtroom. In recently, we have to see many cases like like Sahara India case. It is very popular in media. Media source. This will be for the and media is rapidly decided he is the accused. He is the accused. No, you have no right, bro. You have only work is to see the mirror of the society, not that like you have to judge the society. So
Madam,
therefore I
conclude,
say
conclude fast. Time is running short.
okay.
Conclude.
Okay. Therefore, I say so media should be act responsibly and ethically while the judiciary must ensure the fair trials, right, and protects the freedom of the press is important, but it cannot override the administration of the justice. Thank you so much.
Next, we have online presenters, Dr. Rumi Thar and Miss Tanya Anya. Dr. Rumi Thar and Miss Tanya Anya.
Madam, you are not audible.
Hello? Tanya ma'am? You are not audible ma'am? You are getting my voice? Are you getting me ma'am? Hello? Hello?
Madam, are we audible? Your voice is not audible.
There is some technical glitch. Next, we have Dr. Loknath Swar, Vaibhav Jimara, and Somaranjan Lekha. Yes, sir. Are you getting me? Hello, sir? Yes, yes, you are audible, sir. No, sir, no, not visible. Your PPT is not able. We are not able to see. Okay, okay. Yes, 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 sir. Sir, sorry to interrupt you. You just come to the conclusion and suggestion part as we are running short of time. Thank you, sir. Next, uh, Dr. Rumi Khan and Miss Tanya Anya. Yes, yes, you are audible. Anya, just don't take much time as we are running short of time. Thank you. Hello. Next we have Dr. Asutosh Bairagi. Is he present? Dr. Asutosh Bairagi. Next, Bhagyashree Mishra. Dr. Asutosh Bairagi. Bhagyashree Mishra. Is anyone present? Chinmay Priyadarshini. Okay, you can go. Yes.
Yes, you are audible.
Sorry, you Jitwai, kindly summarize your presentation. Yes, I'm late, huh? Next, we have Dr. Pradakishore Padhi. Yes, sir. Yes, sir. Yes, sir.
Sorry, kindly conclude because we are running late. Sorry to disturb you, sir. Time is running short, sir. Kindly conclude. Kindly conclude, sir. Am I audible, sir? Am I audible? Am I audible, sir? Could you please conclude, sir? Time is running short. Could you please conclude? Okay, sir. Thank you, sir. Thank you so much.
Next, we have Saraswati Sahu. Saraswati Sahu. Okay, ma'am. Kindly conclude in 2 3 minutes, ma'am, as we are running late. Yes, ma'am. Yes, ma'am. We are on. Yes, ma'am. Yes, ma'am. Ma'am, kindly conclude. Conclude, ma'am. Thank you, ma'am. Thank you.
So before extending vote of thanks, would a Kothare Kavi and Pasishun. I will speak in Oriya. Those who are in online also, I request them to please understand it also.
Yes, sir.
ଥରେ ଜଣେ ଋଷି ଗୋଟେ ଗାଁକୁ ଯାଇଥିଲେ। ସେଦିନ କଣ ହେଲା ପ୍ରବଚନ ଦେବେ ବୋଲି ସନ୍ଧ୍ୟା ବେଳକୁ ସମସ୍ତେ ଆସିଲେ, ସମସ୍ତେ ବସିଲେ, ସେ ଋଷି ପ୍ରବଚନ ଦେବା ଆରମ୍ଭ କଲେ। ତାପରେ ଅଧଘଣ୍ଟାଟେ ପରେ ଗୋଟେ ଗୋଟେ ଲୋକ ସବୁ ପଳେଇଲେ, 50% ଲୋକ ଖାଲି ହେଇଗଲେ। ଭାବୁଛନ୍ତି ଯାଉ 50% ସିନା ଖାଲି ହେଇଗଲେ, ଆଉ ତ ଅଛନ୍ତି। ତାପରେ ଏମିତି ହେଇ ଲାଷ୍ଟକୁ ଗୋଟେ ଲୋକ ଥିଲା, ହେଲେ ସିଏ ଆଉ ଟିକେ କହିଲା ଯାହା ହଉ ସେ ଗୋଟେ ଲୋକ ତ ଅଛି, ମୁଁ କହିବା ବନ୍ଦ କରିବି କଲି। ତାପରେ କିଛି ସମୟ ଗଲା ପରେ କେତେବେଳେ ତ ବନ୍ଦ କରିବେ, ସେ ଲୋକକୁ ଆଉ କଣ କରିବେ, ସେ ଲୋକକୁ ପଚାରିଲେ ଏ ସମସ୍ତେ ପଳେଇଲେ ଆପଣ କାହିଁକି ବସିଲେ? ନା ଆପଣ ଯୋଉଟାରେ ବସିକି ପ୍ରବଚନ ଦଉଛନ୍ତି ସେ କମଳଟା ନେବି। ଆପଣ ଯୋଉଟାରେ ବସିକି ପ୍ରବଚନ ଦଉଛନ୍ତି ସେଇଟା କମଳଟା ମୁଁ ଏବେ ଦେଇଛି, ଆପଣ ଉଠିଲେ ମୁଁ ସେ କମଳଟା ନେବି। ତେଣୁ ମୁଁ ବସି ଆପଣଙ୍କ ପ୍ରବଚନ ଶୁଣିବାକୁ ବସିବି। ତେଣୁ ଏ ଅବସ୍ଥା ଏଇଠି ହେଇଛି। Anyway, thank you very much.
Thank you so much, sir. Jai Jagannath. Hare Krishna.
भाई हमरा माइक
खाली 10 टा दो लाइक कर
सोशल मीडिया पॉइंट्स ऑफ सोशल मीडिया सेलेक्टिव तो ना अच्छी ओ जाना अच्छी करे
मुगल 5000 दे तोर